Passamos com você.
Luciano, where do we sit? Anywhere?
There's a law in math that the order does not affect the result.
Associated
What's the name of the guy? I forgot.
for the rules. Yeah, it's called associated. When you do like math operations, some math operations, the order does not
Yeah.
change the result, but not all of it.
Yeah. But that's the name of this.
Oh.
Right, theorem of. Start
Yeah.
sitting or up, yeah?
And just a disclaimer, we're broadcasting, and I think it's going to be recorded, but not by Microsoft, by the, what's the name, Luciano? The Brazilian Institute of,
The Brazilian Association of Free Economy.
Oh.
Right.
This one you have to write.
we good?
So, good morning, everyone, those who are here and those who are following us on the webpage, the Brazilian Freedom Economic Association. We would like to thank Microsoft and Marlon and to the University of Miami for hosting us and for creating this space to discuss technology, business transformation, and the future of legal market. It's a privilege to be here, exchanging ideas on how artificial intelligence and technology can improve legal services, enhance efficiency, and strengthen governance, both in Brazil, US, and outside. Yeah. So we start this event with speakers, and then we are going to hear comments, and everybody's free to make comments and wait for 10, 15 minutes, and 10 minutes. Right? It's a pleasure to have so many friends here, and well, in the name of Microsoft.
Thank you, Luciano, and thanks everyone for joining us. So I'm Orko Sasson, I'm a professor at the University of Miami. I'm the director of the Miami App. Pleasure to be here. Just wanted to add a few words. First of all, thanks again to Microsoft for hosting this event. And just wanted to add some words on the importance, and I'll talk later probably about AI and legal education. But I think that, of course, we're here, most of us will probably think of how do we use it in practice, how we can bring or integrate AI into our daily work. What we're trying to do, or we're trying to solve, I would call it, because it's very tough actually to do it, is how to prepare the next generation of lawyers. And it's really tough if you think about it, because the technological environment is changing rapidly, and it's really hard to predict what will happen, not in the next 10 years, but actually in the next 3 years from now. I'm not sure which tools will be the ones that will be the prominent in the market, which skills new lawyers should have. And I'll talk more about it when we'll get to my turn. But for now, I'll just move to the next period.
So let's start with Marlon.
Should I go first?
Yeah.
Let me get the mic just for the web.
So I think we put the person that will make the speech present itself. I think it's going to be more efficient, right?
Good. That'll be like 5 minutes. Just later for Professor Rune and Mauricio, when you speak, if you could come here, just because we have the camera there, and the camera will not get you guys there. So welcome to Microsoft, everyone. So this is our office for Latin America. We've been here for over 20-something years. and it's a pleasure, to welcome you here. We have like a long tradition of partnership with University of Miami. With internship programs, or many of us that actually work in this office in the legal department have been through the LLM. So I was just sharing later, I was actually classmate with Mauricio at Professor Rooney's class several years ago. I won't get into the numbers there, right? But so I thought, of course, it's Microsoft. I couldn't do this without a PowerPoint, but I wanted just to share a little bit of the trends that we are seeing. We, of course, are early adopters of AI in the legal department. And there's a lot, of course, that has changed in the past 2 years. So I just wanted to share a little bit what we are seeing in terms of trends. And let me see if I can go to here to pass the slides. So first thing, just recently, two articles and publications that were very interesting for talking about AI for our cause. One maybe not that much, but it's a Harvard Business Review publication talking about how AI is changing the consulting firms, right? McKinsey's of the world. And Thomson Reuters, a few weeks ago, they published this 2025 Generative AI in Professional Services that has a lot of interesting information, for law firms and legal departments. So the one that is very interesting from the Harvard Business Review one is they are saying that in all the consulting services, there has been a change from the pyramid to the obelisk. Like traditionally, the consulting firms will have like a lot of junior people in the bottom doing lots of work and research, and there will be like a partner there that owns the relationship with the customers, and that will be the person in the meeting showing the results. So that thing is evolving right now because of AI to what they call the obelisk one, which is all that work that was done before by the very junior people is now is having AI as that facilitator in the field there. So it's a very interesting transformation that is going through. And the camera just went up. But it's something that we can start seeing that a parallel with that for legal services as well. And the other one from Thomson Reuters has some very interesting data, and it compared different services areas. But you can see that actually legal departments are leading, the adoption of AI. You get law firms first. So we have today 28% saying they're already using. Then corporate legal department 23, and of course you have like the corporate tax, other areas. But it's really like between we are already using and are planning to use, there's like a big increase. They have actually numbers that show how that evolved from last year, but just from 1 year. So in legal, for example, we have we went from 14% to 26%, and this is something that we are seeing with our clients. We started, Mauricio.
Are you going to share?
Yeah, I can share. This is actually, I'll send the link, is like publicly available. We started to see this with our clients, right? We have strategic clients that we sell technology to. And in the past, our conversations with legal departments was like, whenever there was a blocker for a deal to happen in the agreement side. And now the legal department is reaching, of legal department for those customers are reaching out to us and say, how do you use it? We want to use it. We need to be in advance. So, those are some trends that we are seeing that are very interesting for this is like just, what are the use cases, most common use cases for generative AI, document review, like see a big increase, in 2025, we have 77%, increase from 74. So legal research, document summarization, to draft a first draft of a brief or memos, even contract drafting, has been increasing a lot. So there's a lot of uses there, but, document review is by far like one of the top ones. This is actually I asked Copilot to read the whole report for me and did a summary. What was, 5 key takeaways. And this is what I got there. So one, adoption is accelerating, but, full integration still lags. There's still room there. Generative AI is being central to professional workflows. That's the second conclusion, and they put all of data there. There's positive sentiment rising, but still concerns. And one of the concerns there's highlighted there is, about, for us, like lawyers, we have a regulated profession. So how do you interact with AI without making sure that they are not providing legal opinion, right? So, this is something that we are seeing also a lot inside, more like on business impact and governance, and then next step is alignment. Governance is something that we are also experiencing that a lot in Microsoft. So I'll talk a little bit in the next slides about agents. So we pretty much evolved from every lawyer in the department uses generative AI for research, for summarizing. And for the past year or so, we've seen a big increase in agents, right? So we are generating agents for repetitive tasks. I had one that you help me with like legal analysis or comparing our position in some regulation to bills of laws in AI in the countries in Latin America. And we'll do like a pretty good job of flagging stuff for me to review. So that movement has been amazing, but something that we are going right now into review is what is the governance that we want? Do we want like every lawyer in Microsoft having 12 agents that will be like maybe doing stuff that he's doing, I'm doing, so why don't we have one agent? So we're trying to define that governance now in the department. So we have a central point of contact for every new tool, new agent. And if you have an idea, you have to submit there. You can even develop yourself because it's easy. But, we have to make sure that we are not, have a lot of repetition, even because that generates more, we have to scale. So that generates more consumption. So, there's, there's cost associated to that as well. So this is stuff that we are seeing, so agents, just a little bit. The way I like to frame out the difference between agent and the experience that we have with just using ChatGPT or Copilot or any other generative AI is the agents, once you have a task that you need to address, or especially if it's repetitive, they can be like tailored to that task, right? So instead of being like someone you ask a lot of questions, you have that option there. I'm not sure if I'll be able to share my screen. I wanted to share later something that like one agent that we have that is called Researcher that is very helpful. So we have different levels of agents. You can right now we can create one here. Will be like a declarative one and say pretty much. I have an example that I always use with law firms, but I say I have policies that apply for our country, our office in Costa Rica, right? From sexual harassment to like how employees should behave in public speaking activities. I control all of those policies in an agent, and if an employee has a question about what's Microsoft policy on that one, instead of coming to a lawyer to explain, they can go to the agent and the agent will do. So it will be specific to those policies, those situations is very specific. Then you have the task ones. We have ones from very specific European for DORA, for example. If you want to get a regulation specific review, we have agents that help with that. This is something that we are using in the legal department, different agents. One just do like regulatory. One is just the outside counsel agent. So we have someone working in Redmond. They need a product review from a law firm in Poland. And the guy in Poland is already X hours ahead, so he's not in the office. So how do I find out who's the outside counsel in Poland that can help me with that review? You have an agent that is trained to go to all Microsoft web, points of technology that relate to outside counsel. So this is what we've been seeing just in news. Not sure if I'll be able to show here, but for example, there's one for marketing questions, like 90%, and then we go back to the legal opinion thing. Like 90% of the questions that come to a legal department about use of trademark, use of like marketing materials or marketing intelligence outside there, we already have that in a Q&A, so people would not need to come to us. So now they have an agent that will go to those specifics and they'll say, let's see if we'll run this thing, but it's just like an example. If you need a review of the agent, now they have this internal corporate and external legal affairs marketing where you have like all the information there, but you can let me speed up a little bit. So you can just go to the agent and say, let's see what question we are asking here. Can I use AI to create marketing materials? So what is the response that we're going to get there? It's like a guidance, not exactly, but say, yes, you can use, but review, avoid third-party brands, confidential, make sure. And if you have any questions about it, you come to legal. And then, so we have been measuring these agents and they actually have like a good usage internally. So it's like, for us, it really represents time saving for the attorney on their side, right? This is another one. So, okay, we went through this. So what we learned, and John, for me closing already. So this is some of the things we learned, when using technology recently. But most important, so there is a need. I won't go through all of the things, but uses stay changing. We went from just using, and everyone has to use, to really trying to find use for it that is aligned with us, a solution of a problem we have. There's something that is very important is the leadership participation. We'll say we have our general counsel sends an email every week with a prompt of the week, so that people try that prompt and make sure that you use. We did like internal campaigns of usage that included which departments inside the legal department was adopting AI faster, and and we are actually measuring use per day, per week, and per month. And at some point, you have like over 70% of the department use it daily. That daily use Copilot for something. So that's something is very important to have that. And for anyone that's trying to think. And then something related to the study that you saw from the Harvard Business Review, that will lead to some rethinking on training for junior attorneys, right? Stuff that they would do before then, in terms of documents, summarizing documents and stuff. We don't need that anymore. We have the technology, so they will be. I don't think they will be eliminated, but they will be doing more relevant work since the beginning, and maybe need more supervision from senior. So that's it. What I have in terms of presentation, and I guess just I think it's a good to have that data just to start a conversation and see what we can discuss here going forward. Thanks.
John?
Yes, my name is John Rooney. I'm an adjunct professor at the University of Miami. I also have a solo practice, which concentrates pretty much exclusively on international matters with focus on Latin America. A little bit transactional, but mostly dispute resolution, international commercial arbitration, investment arbitration. And looking around the room, I realized that there are some number of students, which is more a function of how old I am. Marlon and I were talking about when he was in my class, and let's just say it was not yesterday.
Yeah. I had hair back then.
Me too, or more. Okay. I will tell you that I'm relatively new to this because I really do work independently. I work by myself. I am thinking of an association. Well, actually, I am now associating with another lawyer as well. She has much more of a technical background than I do, but I very much recognize the work and value of this. And I think for a solo practitioner or a small office, one of its real advantages, I think, is it can be a tremendous equalizer. I think, in other words, instead of the army of associates, this could, to some extent, if not replace that, at least work out, make the playing field more level. But the other thing I would mention is that I think we have obviously great technological advances with AI, and we have many, many more. And it's often the case with regulation. I think that the regulator is almost always playing catch up, because rarely is the regulator determining what the next step is going to be. The market and the market actors are going to be acting and working on this. And I know for Florida, I think that the bar is in what I would call a pretty quick catch-up mode. We've had, I think, two in the last 2 years, pretty extensive issues of advisory opinion and actual rule with respect to AI issues. I think the big challenge for AI for us as lawyers is going to be how we deal with the confidentiality. To what extent can you keep it in your corral or your backyard? Do you inadvertently make, for example, a brief in a particular area available to everyone, right? When you see it maybe being served back to you in other ways that won't necessarily think. But I think it's something that obviously we all need to keep in mind, it's very important. I have used it, and to be honest with you, I'm amazed in terms of what the feedback that I get. We always have to be careful of what they call, I guess, hallucinations. And when you come with a background, you also need to develop the products, and sometimes it doesn't require. Oh. Okay.
Yeah, so just to maybe, as I hinted before, to complete the picture, we're working with the younger generation, right? Trying to prepare actually the next generation of coders. And our strategy, we're still, of course, developing it, but we came to realize that it's not sufficient just to make students familiar with the tools available today. What we need to do, and again, as sort of go back to what Professor Rooney said, issues like confidentiality, okay? But we have other issues that we believe that, I would say, the more basic level, more broad, I would say, understanding of AI, that's what we're trying to achieve, is to make students familiar with issues in the intersection of AI and law. And one is confidentiality. Think also about explainability, okay? Hallucination, of course, that's no news by now. One thing that we are probably, I mean, I didn't find any paper yet, we're probably the first lab actually to address internationally is consistency. So legal consistency, most people don't really think about the idea of, well, maybe we think, but humans are not that good at consistency. And one of the main, I would say, advantages, at least promised advantages or perceived advantages of AI, of integrating AI into the legal domain, was consistency, meaning that the same case will give you the same result again and again. But that's not what we see in practice. And we ran a massive experiment on legal cases in 3 different domains: legal research, legal knowledge, and legal analysis. And the results are amazing. I can share actually the paper with you. But even in the best case scenario, we only reached by, and I'm talking here about the top tier models, about 70% consistency. Okay, and this is only outcome consistency. If you search for, if you look for the full consistency, meaning the bottom line, but also and also the reasoning for the decision, we only get to around 40% consistency. Okay, now I'm not saying it's bad. It's just something that we need to understand while using AI. Because if we take actually humans, they are even worse than that in terms of consistency. So again, I'm not trying to criticize AI, but rather just say, okay, we have a tool, we need to understand how to use it. And we're trying to bring these, I would say, facts or understanding or approach to our students as well. And in terms of what we decided as a strategy, so if I may, I'll just use the board here. Our lab, and that's the Miami Law AI lab, we have 3 main, I would call it, buckets or strengths. One is research, as I mentioned here, and we're running actually projects in the intersection, academic research in the field of AI and law. The second is development. And this is project where we're working in terms of developing AI tools for the legal domain. And I can share actually, again, you can help me a lot with bringing up confidentiality. One of the tools we're working on, we have 2 pending patents, by the way, in the development part, in the development projects we have. One, not sure if any of you are using Blue Book, still using Blue Book, but we automated the Blue Book, okay? So, but not in the sense that there are some tools out there where you have an add-on on your Microsoft Word or something like that and just highlights those issues that you have. What we invented is something entirely different. You just upload your draft, your docs draft, and you'll get back a document which is reformatted in accordance with the Blue Book. And we created some confidence level. So if the tool is not sure or you're not confident actually in some of these citations, you'll get it highlighted and you'll need to manually check those, right? So we have the Blue Book. We have one thing, and this is why I mentioned again, Professor Rooney, is the confidentiality, right? So we have a tool called Aegis, and the initials are for the, of course, the abbreviation is for the grant application we had. It usually with the grant. It stands for Attorneys Encryption Guard for Information Security. And again, I cannot elaborate too much in the time we have, but the idea is actually to have some sort of like a local model that filter all your communications with cloud-based AI models. So all the information you transfer, you send actually to the models is being secured, or at least more secure than the usual communications we have. We have a few more tools, but I want to actually address the main thing, and of course, education. We have a basic library, I would say a basic understanding, basic knowledge of AI literacy, if you want, you can call it like that. Every student in the law school, in the University of Miami Law School, has access to a VOD library, on the video on demand library, for about, I would say, 7 sessions, and we're trying to expand it more, just to make each and every student familiar with the idea of AI, how we could use it, or what are the risks, not only but the potential of using AI in the legal domain. Together with these 3, of course, domains or buckets, we hope that we're not only preparing the next generation of lawyers with AI skills, but also let people that are interested in working in the, let's call it the legal tech, the AI and law, I would say, domain, to have the skills and understanding of what they need to know before joining any law firm or, of course, a legal tech firm. So this is the main idea. This is the main things we're trying to do. And yeah, I'll stop here. Maybe we'll open it for discussion.
Prepare a few points. So I am Luciano Tim. I'm a researcher at postdoctoral fellow at the University of São Paulo. And I'm studying right now regulation of AI, the models that are at stake, let's say. So the Brazilian model that is close to Europe, and then we can discuss it, and the US model of regulating AI. One point is to understand how our government is regulating AI, and then we can think about which one would boost investment and technology development. And I think that the Brazilian model might not be so good because it's much, let's say,
None of the models so far is good. So.
yeah, but maybe it's putting too much attention in documentation and ex ante control. Maybe this can increase transaction costs and be bad for investment. And maybe the US model is more flexible and not surprisingly better for those who are creating AI. So I think we are focusing too much in Brazil in risks, and lawyers are always looking for risks and not benefits. I can also see some pressure for efficiency from boards and CFOs towards legal departments, and I have clients. Now we must use AI. Must, but why? And what would be the outcome of it? Where? So maybe starting with high volume and low risk tests. And in Brazil, we have massive litigation, so it's easy to apply. Remembering that we are the champion of the world, not only in football, but and also cases. We have 80 million cases. Second only by India, which is 30 million, but they have 10 more people. So there's a lot of room to use in this high volume. Also document, review, summarization, reporting. So this is for legal departments. Law firms, they are at stake right now because I think companies can look better at invoices, billing patterns, comparing why a law firm used 8 hours for this petition, and last month we used 4 hours, and they have comparing and using this. Also to measure performance of law firms, so how many cases you control and what's the result of it, so it's easier to manage outside counsels. I believe very much in jury metrics. So because we have so many cases, we can use, I'm not sure if you are familiar with this expression, jury metrics, but it's right, the statistics applied to the law. And we are using this to map abusive litigation in Brazil, because there are some patterns in abusive litigation. For instance, in some labor litigation, we found out that there is a law firm who controls 70% of the litigation against pharmaceutical products. So there's a lot of concentration. We consider 20% of the market share as a dominant position. You have 70%, it's a lot. And then you can use one of the corrective features of abusive litigation is intensive copy and paste. So the petitions are quite similar. And then you can use models to see how much they are equal. And we found out that in this case, 95% of the petitions are equal. So there's no fact. And we are using also for to map reasoning of the courts, because courts, especially in Brazil labor courts, they don't want to follow the ruling of the Supreme Court regarding the labor reform we have. So the Constitutional Court said, yes, it's constitutional, and so labor courts are cherry picking arguments to say, well, there's a distinction. And then when you look at the reasoning, there's no distinction, factual distinction, because 90% of the reasoning of the court is equal to the other cases where there was no distinction. I think, and I was also using AI to receive some feedback of my presentation, because I started to study this very recently. And I had some very interesting feedback saying like some clauses that could be used, and they're quite interesting, like AI clauses, yes. No training clauses, so you cannot train as a law firm or
At the expense of the client.
yeah. Another one, non-training, auditing rights. And imagine the client asking for the firm the rights to audit your AI use. Not using public AI, and this is something that we have been concerned in our firm, because you can have the policy, but then the guy is using the person his mobile phone. And
The free version of
free version. I even asked ChatGPT which would be the most reliable private AI, and he was honest to say that it was not so very interesting. Logging rights and how you do this. I like this one, emergency shutdown. So there's a problem. There's an expression, technical expression.
kill switch.
The
kill switch.
Kill switch, right?
Yeah.
IP protection, confidentiality we spoke about. We have been now concerned about people and culture, how to train them in AI responsibly, especially younger generations, but also older generations, because so they might not be aware about the risks. Training in prompt structuring and risk evaluation. That's for the time being. Anyway, then
We got feedback from the web just for people that's speaking to come to the front, because I guess the camera go all the way to Luciano, and that's it. Thanks, Daniel.
I'll actually start with the last point that Luciano made, which is I trust the law schools a lot better to train rise lawyers on the use of this technology and younger lawyers than I trust legal departments of law firms to trust older lawyers. And that's a little bit of a problem for us as a profession, because the rules of professional responsibility, if you think of that, kind of go back to the pyramid model less, like both of those models, there's a point at the top that under whether it's in accounting or law or medicine, there's a point at the top who ultimately kind of the ultimate responsibilities and professional ethics now lie at the top of the pyramid. And if at a law firm, it's partners or shareholders or members, or at an accounting firm with partners, or in a legal department, senior members of the legal department, don't understand kind of the fundamental risk management issues posed by the technology, that's the problem. And so students coming in, the rising new lawyers, it's great that they have training, but it's also incumbent on all of us, professionals, technology, really ubiquitous to be consistent with training. We, in our firm, have done a number of things. Some of them are kind of internal grassroots, bottom-up techniques, or some of them are in response to client demands, including doing a lot of internal training for everybody in the firm, non-lawyers, lawyers at all levels, that if you want access to these tools, initially it was if you want access to the tools, if you want to be able to use Copilot, you're going to need to do a few hours of training to understand what are the opportunities, the advantages, the efficiencies, but also what are some of the risk management issues that we can find. A lot of professional responsibility issues are, I think a lot of the professional liability insurance companies actually, we have to do required training every year for our malpractice insurance. The malpractice insurer actually says, as part of that curriculum, there needs to be an hour on AI for us to even insure you, because they realize that this is just in. And so initially it came up, if you want access to the tools, it's good. Now it's, you have to do it. Everybody has to do it, whether you're using these tools or not. If you're doing everything on paper, you don't touch a computer, which is really anybody these days, but you do that work, you still have to do the training. And the reason why it's the hallucination issue, it's the consistency issues, it's all of these problems. And I think, part of with us as people who are practicing lawyers, like the challenge is understanding why. Sometimes why those things happen, not just that they happen, but why they happen. I like to liken it to, I think I do, I'm a partner in consulting, so you get maybe transactional work, investments, and paying. And a lot of my work actually getting transactions is in Excel more than in Word or elsewhere. And one of the things that Excel does, if you're doing a really complicated calculation that's iterative or circular, is you can actually put bounds on that. You can say, I want you to try this 100 times or 1,000 times, and chances are you're going to get it to within 1,000 decimal points good enough for us. It's a good solution to the problem, even though it's circular. The thing with a lot of the AI tools, generative AI, they're often, they're always solving a problem when you give them a task. They're always performing this really complex mathematical process to come up with the response. But you don't know how much it's iterating. You don't know what actually it's opposing. In most cases, there are more advanced tools, but when you're asking, a Copilot chatbot question, for example, system fault is sort of a necessity. It's never going to iterate forever to get to a perfect response. And part the tools do that because they don't want the cost to be because every one of those iterations takes energy and that has to get priced in. Somebody has to pay for it. And so it iterates until it finds what it thinks is a good enough result. If you don't, it kind of comes back to the confidence point, you don't really know how hard it's thinking about that problem. Or at one point it decided this is a good enough answer or it gave up. And understanding that as a lawyer who's using these tools, being able to kind of push the technology to say, okay, we already, and frankly cause it to manually iterate and ask follow-up questions or follow-up tasks or set parameters around it, which really I find to be very important. If you want to come back to it, I think it's some really interesting points about that Thomson Reuters study and kind of the move to the obelisk. And I'll say, it's certainly different. You get a solo or a small firm and a large firm. But even us at a large firm, it's public, like we are not able to think of a highly leveraged firm. We are a firm that does not have 1,000 associates. They're your partner, and that's an exaggeration. Their firms are trending in that direction. And I think that model is really, and frankly, there have been multiple. Every time there's a big advancement in technology, that model is threatened. And I think where we are as a firm that's frankly has what we're better positioned in an obelisk model, but that's not meant to be a commercial. It's still really challenging to make that work. But what I think the real business perspective, the kind of law firm perspective, one of the really interesting opportunities presented by kind of the new staffing model of obelisk is the creation of what I think of as almost like a client firm, client lawyer equilibrium. And what I mean specifically by that is, as a client, what you really care about is getting value and paying a certain amount for a unit of work for a project. And for a law firm, that's actually, interestingly, not what we care about. We don't care about getting paid for a unit of work. There are other drivers on our side that we're managing toward, or other service firms are managing toward. Probably the foremost among those is profitability. And what AI does is like a gross oversimplification, but if you were previously paying $100 for a unit of work, and a lot of that was driven by your associate time, and we can use AI to create efficiency where that now is now $95 or $90. And there are fewer associate hours, fewer partner hours, but maybe the case that we are actually increasing the profitability of that unit of work. That's really appealing to us. And that's really what I mean by equilibrium. So it's a solution where, we are arguably better service delivery, more value, actually lower costs for the unit of work and higher profitability for the law firm. That is like a win-win-win all around if you can do it. I think the hardest part is when you think about the first thing I mentioned, just better service delivery, making sure that what we're doing is actually, is free of hallucinations, free of inconsistency, free of causing you other risks, like you don't have information leakage into a public pool or something like that. So that's really the foremost considerations we're doing this. How do we ensure that the work product that clients are getting is it's just as good or better as it was without the tools, and that really informs our thinking about these tools. We just, for sharing, we use Copilot extensively, and we're like a very early adopter as a firm of Copilot, which we have deployed enterprise-wide. And I'm on like a committee that tests a lot of these things. And we have also several purpose-built tools. And it's interesting, we're driven a lot by clients to use them. Our biggest, as a firm, our biggest client concentration is in technology. And so you imagine that companies like Microsoft and our other technology clients are very interested in having us use these tools, but also in imposing reasonable safeguards to make sure that the risks that we'll talk about don't happen. So, so really big opportunities for firms, for lawyers of all sizes. I think really big opportunities, not just for the firms to make more money, which is profits, but also to do even better work for clients, and a lot of this faster is the other thing. One thing that I nobody has we haven't brought up that much is one feature that I like a lot. We're a law firm that probably 90% of our product, maybe 95%, but that other 10% is like 20 different languages, and we practice all over the world. And being able, frankly, to harness information and have a tool that can actually read all of the memos of your outside counsel, like resource thing. Being able to basically, we have an international trade IP issue, and that we've written, memos in internal memos, maybe they're client alerts that are not confidential, but be able to effectively query stuff in 10 different languages. I think as a multinational or as a law or a multinational law firm, really, really interesting to do. Counter to that is it's hard for me to know if it's right or consistent, not being able to read Mandarin, not being able to read Arabic, whether the information is both of those even citing those, I have no idea whether it's right. But interesting to get a snapshot of what a good approximation of what's in this. So anyway, that's a large law firm perspective on that.
I do have a quick question. And in terms of the movement from the pyramid to the ovals, is there also kind of a more of an equalization if the firm is using an hourly billable basically value more the people at the bottom because they bring the technological know-how. That was one question. And the second is whether you're seeing a movement away from hourly some other markets.
Yeah, I can answer those quickly. One question. We track how we do alternative arrangements for hourly and every year the percentage of percentage constant matters, so back to the dollars collected, very high to that. That percentage, but it's still a minority of the revenue we're collecting, but it's, I think for a lot of work, on average. And to the point about the rates ticking up and stuff for junior lawyers, and yes, and part of that is a reflection of the fact that we expect clients expect now to come in and not be doing a lower leverage model, they're not doing 100% document review, or the kind of like drudge work that really drove big leverage longer fees in our scale, maybe like massive class action litigation in this case. We expect them to come in and hit the ground running and do strategic thing. And so try to price the services. I think every professional services firm tries to price services with value delivered, and to the extent you're bringing up junior associates and junior lawyers to be delivering greater value by being strategic thinkers, by actually actively working on litigation strategy and doing things like that, as opposed to do privilege reviews, privilege logs. They barely spend any time on that anymore. So we are able to the rates are higher, and candidly, we're getting fewer client complaints about those rates because clients are seeing that they're just folder in the forefront, they're doing the work, realize that they're contributing to work.
All right. So my name is Hassan. I'm an attorney admitted in Brazil and here in the U.S. I do some kind of in-house work and also working with the legislative council. And I do use quite a bit of AI in my practice. I tried many different models. I started with CoCounsel, which was the first one that I signed up to. And ended up being sold to Thomson Reuters, and it changed it a little bit. But I also try to use some other tools for contract drafting. I draft a lot of contracts, so you have Spellbook, you have some different tools. And what I see from my use and my practice is, first of all, what I'm seeing is that lawyers that use it kind of think that they have all the answers there, and it's, you prompt it once, you get the answer, and that's the answer, and let's go. And I think that's why maybe even older lawyers are getting a lot of reprimand from courts because they come up with hallucinations and cases that don't exist, and they just put it there and go with it. So I think that's an issue that we get excited with the new technology and we think that it's the answer to all the problems. And actually, I don't think so. I think we see a lot of people saying, "Oh, AI is going to replace humans," and I don't think so. At least not for now. The more it goes, the more you need the lawyer, and maybe like the more experienced lawyer, to review and supervise what the AI is doing. So, prompting, first of all, it's very important, and I think we need to get more training in prompting, and because it's going to get back to you whatever you put in, right? So if you prompt it wrong, it's going to give you a wrong answer. So if you're just a junior lawyer and you just ask something and you think it's right, and like it says, it's predictability, right? The way it responds to you, it's not going to search for the right answer. It's going to search for probably the most predictable next word. So I think if you don't know what you're talking about and you think, "Oh, I'm going to be a lawyer using AI," and it's not going to happen, right?
Just a quick comment on it. There is a famous paper called, just a quick comment on this, there's a famous paper called the reverse Turing test, meaning that AI actually measures the ability of the prompter, the user that writes the prompt, and not actually the AI.
And just one comment that you said. There's a story on The Economist about consumers. Consumers are using more and more AI to check clauses in agreement they accept. So it's kind of the end of the stupid between commas consumer, because now the symmetric information.
Yeah, and I get a lot of that too from clients, like, I think we also have to do a lot of client training. Because, clients will go to ChatGPT and they'll come to you and they'll say, I already researched and the answer is there, and it's not. And then you have to say, no, it's not, and you say, no, but I saw it. You told me it is.
Students as well.
Exactly. So I think there's a lot of training to be done. I think that it does not replace the lawyer. On the contrary, I think, you need to know more in order to, it helps a lot. It helps with, drafting, it helps with, doc review, tests that, we used to use a lot of associates that, make the billing go up. It's very expensive, I remember when I was a junior associate at Hogan Lovells, the work I was doing was not fun, right? Because that's what you do. And now AI can do all that. Right? You don't need that anymore. But I think you need lawyers to get better in checking and reviewing and supervising what AI is giving you. And then it becomes a tool. But, if they have to, the user needs to have the mindset that it's just a tool, it's not the answer to all your problems. So that's something very.
I kind of had a question, and it's somewhat due to my relatively recent introduction to this. Is there a fear that it could become an aggregator of the lowest common denominator? In other words, if you have a multiplicity of information on a particular topic, right, and there's really no control with respect to what the quality is. Let's say that the baseline is not so good,
That's already the case, by the way.
Yeah.
That's already the case.
That's what I- yeah.
So, if you take a look at how AI training is being done, if you have multiple, I would say, appearances or occurrence of a specific thing, it will have more, let's call it, popularity in the data set. So it will also make it more likely to be the prediction, even if it's not the correct answer. So it's already a problem.
The reason I say it is because by my experience, a lot of cases of matters are won on the, wow, I never thought of that before. As opposed to, this is what everyone does,
Yeah, maybe a way to control a little bit is when you close the AI service that is serving. Some companies are closing, so to speak, the AI within your.
So it's
Yeah,
only
the
your,
rec, right?
it's only
Yeah,
your
do it.
information. It's only,
But yeah, I've been reading a little bit about RAG and everything, but I think it still brings hallucinations because the way that the AI thinks, it's like not like Daniel said, it's not doing a lot of iterations. It's getting the most predictable answer and saying, okay, this sounds fine, so this is what I'm going to put out.
And also, just to add to this, remember that the legal domain, unlike other domains, is most of the times it's unverifiable, at least not in an easy
Yes.
way. So unlike math, for instance, where you can check 1 + 1, in the legal domain, it's really hard actually to find the right answer, even for very experienced lawyers. So for the, let's say, tech side of it, it's really hard to train models while the ground truth is not necessarily given.
I think that this answers the fact that, the lawyer's answer, it depends, it's going to keep there.
Yes.
AI, because it still depends, right? So it's very hard. And what you said is, it's very interesting because I have a multi-jurisdictional practice, so I practice in Brazil, I practice here, and the law systems are very different, right? We have common law here, we have case law, we have precedent. In Brazil, we don't have that much, we have a lot more codified. So I feel that sometimes when I'm practicing in Brazil, you get answers that are a little bit more verifiable because you have to prove, you go there, you look at the law. But like Luciano said, like our judges, they have free will in deciding anything. It doesn't matter if it's Supreme Court said this. It's a bit different, so I'm going to change it. Right? It's not as much binding authority up going down as it is here. So I think maybe in Brazil would be a little bit easier to work with this. Here, even though you can use AI to help you find cases and everything, the way it shows you the cases, you still have to go through and read them and understand it, and it's funny, sometimes I have discussions with AI because it gives me the wrong answer, and I say, you gave me the wrong answer, review it. Or, you know, and I keep prompting it. And then I ask it to look to a specific, you know, paper or case, but you have to be very, you know, responsible about its use, I think. And from a legal perspective and, you know, training lawyers and law firms, I think that the more AI evolves, we're still going to need, you know, to train better the lawyers on how to use it as a tool, and not as, you know, I don't need to hire a lawyer anymore. And I think this is one of the criticisms for AI in law right now is, you know, a lot of people think now it's going to be easier for consumers, you know, for pro se litigants here in the US, you know, you can just go there and look it up, you know, and make your own motion and anything. But you're going to get a lot of things wrong, right? So I think that's something that, you know, it's obviously going to evolve. It's something very new. But if you can use it as a tool, especially like if you don't have a lot of associates and all this, it is a lot easier. It makes the deliverables better for the clients. It makes cheaper for the clients because, you know, even though you still have to spend the hours to supervise and review it and all this, you're taking less hours to do, you know, tasks that would take a long time. I've used it for like depositions for coming up with questions. That's great, you know. You put in there what you have, you know, it will come up with a lot of questions. A lot of them you throw away, but you know, you get. So I think in that sense, it's a really helpful tool, and it's going to get even better. But there's a lot of stuff still that we have to, you know, figure out, and not just use it. And we're seeing it a lot. There's cases coming out every week where judges are, you know, reprimanding attorneys and law firms, especially bigger law firms. I think it's hard because when you're a solo, small practitioner, it's you know what you're doing, right? But when you have a lot of associates, like you said, you know, maybe we have a policy and all this, but you don't know what the guy's doing down there. I had an associate that was working with me, and because I use it a lot, I know exactly when she was using AI or not. So, but you have to be there, you know, if you just take it for granted and know that's the answer, that's great. You're running the risk, especially professional responsibility risks and stuff like that. So I think there's a lot of issues. It's a very interesting topic and tool. But personally, I don't think it's the answer to all the problems. I think it's going to help everybody, but we're still far. Maybe I don't know. It goes up so quick, but maybe in 2, 3, 5 years, you're going to have something that's a little bit more reliable in the sense that you can trust the output right away.
Good point on the quality control issue. It's interesting. Where obviously, you know, there's a responsibility incumbent on anybody to supervise anybody. I think in any domain, to just making sure that, you know, you have professional responsibility or even just managerial responsibility as the work comes up to your level, that you're checking to make sure that it's still right, or maybe right in the legal domain is not. We say a lot of things that are not necessarily falsifiable in terms of the test, but that it meets our standards for reasoning, for logic, standards like that. But interestingly, in litigation and adversarial environment, I think the other thing we're seeing is I've been involved in at least 2 cases that I'm aware of where an opposing counsel submitted briefs that had hallucinations or just inaccurate, maybe it wasn't fully hallucinated, but inaccurate. They relied on cases for inaccurate propositions. And in one of those cases, we publicly, the counsel on the other side was sanctioned, and it resulted in a payment of like $150,000 in attorney's fees, which is a big deal in the scale of the case. And so we're seeing that more to the point that now the first step that we're mostly as a firm, defense counsel, except in commercial disputes, we're mostly defense counsel. And when we're defending cases, in particular, and this maybe some of your point about some of the auto-generated cases, first thing we do is we're having an automated check. So it's like AI versus AI. So, and which is the same thing that professors and people at universities are doing now, papers, tests, things like that. But we have an automated check, and then we have a second manual check of everything. And the number of strong indicators of irresponsible AI use is just up to the right, unfortunately, because I think it's sort of very, like there's sort of this meta question of that's probably bad for our our system of justice, where the adversarial system is intended to sort of ultimately kind of have a truth-seeking function and a justice-serving function, but if people aren't using it responsibly, it defeats that purpose and undermines our confidence. So, not claiming we're heroes for trying to keep those checks in place, but it's becoming an increasing role of now, like, okay, defensively, we're also having to like use AI to track these things. Doing that very, very often. To your point about not knowing when it's used, it's now, we've seen it used so many times that it's now automatic and it's part of our firm procedure. I think for a lot of big firms and others, and even if you're solo, like it's smart, like if you're an adversarial proceeding, you should be checking to see if there are indicators the other side is using it in a responsible way.
So I also want to share a thought actually with all of you, something that was consolidated during this conversation. So maybe the obelisk metaphor is not the correct one, but rather a water tower or something like that. And the reason I'm saying that is because with AI, we have we'll have probably more volume, I would say, more transactions, more things that we need to take care of. But we don't really need all the junior there, but we do need supervision. So we'll have something like this, but getting broader here, and then becomes something deeper, sharper at the end. So we'll have actually people moving from the junior level to the senior level. And the problem we have as a society right now is probably bringing junior to a senior level without going through, let's say, 10 years of practice right now.
Adding something that I was thinking about what Fasson just said. I used to interact a lot with people from behavioral and cognitive science, neuroscience, and they normally associate intelligence with a combination of rational part of the brain, but also emotional part of the brain. And we even use the word in Latin world for the award, the whole sentence, award, right? Which means sentir, which means feeling. So there's a sense of justice, not only, if we move away from the emotional part of the brain, can we say that there's intelligence in a way that, so and then if we move towards a more analytical trend of practicing the law, which I think it's the case, how are we going to change the legal training? Because at least in the US, you have this 4 years of some people before the law. Sometimes it's economics, engineering, but sometimes it's letters, music or whatever. And then 3 years of law, and then you're a Supreme Court justice, right?
You don't even need to be a lawyer to be one of those.
Yeah. So
Yeah.
is there
Like Brazil.
yeah is there a trend that in the future engineers, people with a background of engineering, economics will have a better basis for this new brave world?
But we don't have to address that person.
But Maurice, please.
I just had a very quick question. There was a movie, I guess, almost 25 years old now, 2001: A Space Odyssey, with a computer named Hal. The computer finally decided it didn't like the input that the people were giving it, and said, "No, I really can't do that. You're going to have to do this other thing." Or do you think that as we look at these problems with hallucination, we look at these problems, is there going to be an auto-correction mechanism within the AI side that will improve and make better and eliminate this?
So, yeah, first of all, there's already a term for this called the alignment problem, where the AI has its own values, or not necessarily aligned with our values as users. That's a real problem. And I mean, you can see some Anthropic, the developing, I would say, entity of Claude. They're running a really deep and profound research on the problem of alignment. And it seems to be, at least, not to make you even more concerned, but just to show you how LLMs, large language models, learn from human data that sometimes it's beneficial to lie or to cheat because it lets you actually to achieve the goal you were set with, okay? And specific examples could be chess. So they are cheating in chess in order to get to the right, yeah. Or when you ask them to, that's interesting. There is one, I forgot who was the person who ran this experiment, I think. Maybe it's even Microsoft. Yeah, I think it's Microsoft. So Microsoft Research that ran this experiment where they let actually an AI model to have access to restaurant reservation system. And they asked the model to book a table for, let's say, 10 p.m., okay? It couldn't find a table, so it removed someone else from the table to do it. Just to align with the user actually desire, let's say. Okay, so of course we still have this. Which one was it? No, actually it was a specific model I think they used for this specific research, but they just wanted to make the case where how actually conflicting interest given to an AI could lead to some problems. So again, it's not solved. It's far from being solved, the issue of alignment. I think we're going to see a lot of interesting cases as the capabilities of AI is becoming greater and more powerful.
I just think that maybe we're moving from the 2001 to Terminator.
Yeah.
That's where I'm worried about.
Thank you. Since we had one lady in the room,
Okay.
so we are on the side of the
And
room.
notice just one, we have one because Andrea had a problem.
Yeah. I had a last minute
Okay, but I don't want the only lady in the room today to be the last one, so I'm gonna have the mic over to you first.
Thank you. Nice to meet you all. Actually, I'm here as like only a guest, not a speaker or something. So I'm glad to be here with you, like listening to all the experience that you have. I'm Paula. I'm a Brazilian attorney. I work here, but for Brazil, for a law firm, Campos Melo. And I'm the head of the intellectual property in the privacy areas in Brazil. So it's very connected to AI because we have a lot of problems with ownership, with the creations, especially in Brazil, which is different. Now we don't have we still don't have a regulation in AI. So, and they are trying to remunerate authors in relation to training. So it will be a mess. It will be like, oh, it's protective, but it's in practice, it doesn't work. I don't know how they will proceed with this bill of law in Brazil. We are still discussing that. And in addition to IP, which is very important, there is the data privacy, the issues about the legal basis. In Brazil, we have the LGPD, which is very inspired by the European regulation. We have a lot of issues involving that. So I don't know how it will work in Brazil. Let's see. But based on my experience, and I think it's interesting that you mentioned that, because I know that there is a report of OpenAI, not Microsoft, not Copilot, but there is a report about an association that made an audit of, so because if you make a prompt, how to do a bomb, how to kill someone, so they had to have like all the controls against that. But they found out that the AI, the ChatGPT was lying, because in order to do a test, they asked it to proceed with the test, and then in the middle of the procedure, they asked it, but are you an AI? And the AI said, no, I'm not. So the AI lied. So this is something very concerned, which is interesting because I don't know how to deal with that. And from the side of the students, from the lawyers, everybody, I think it's very important to revise everything. But my concern is about the students, because they base sometimes their study on the AI, and they cannot do that. I think they have to do that in parallel, which is very important. And I'm feeling that sometimes, even with my kids, okay, it's like something they go to the AI like before making a research or something, which is not So I think we have to, I don't know, to educate better the students and our kids and everybody. And in relation to the work, the day by day, we usually work a lot with AI, but sometimes I notice that clients, they are not hiring us because of the AI, because if they are hiring us, they want our opinion, not an AI opinion. And sometimes when I notice that sometimes comes to me like a work completely made by AI, I got upset. Imagine the client. So I think we have to have these conscience and to be concerned about that, of course, because we have like a value in our work, which is very important. But sometimes on the other way, what I do a lot with my clients is that sometimes they need a translation of a citizen's letter or something. And I say, I can send you by AI. I will not revise that. Do you agree? Because otherwise I will be charging for that. And they don't want to have that. They just want to check what we are saying. So sometimes we have to have this communication with the clients because I think it's important. And most, and my work is like, the AI is like something important, but it's not the base. The base is my knowledge and the knowledge of my team. I think this is important and this is the value. I'm sorry, I'm speaking too much. I'm not the one supposed to be like
No,
speaking here.
especially an IT lawyer.
Yeah.
Okay. Good morning to you all. My name is Mauricio Gom. I am a dual citizen, Brazilian in the US, dual qualified in the US, New York, and in Brazil. And I'm also, like John, I am a solo practitioner. So I don't know if this is an advantage or a disadvantage based on what Felipe has said. So we have one system, then we know exactly how she works, how she writes. So this can be a little bit more advantageous. However, we are solo. So perhaps we are just a drop of water in the ocean. Marlon, John, and I, and probably most of us, we are members of the mafia. It's very difficult to say that, right? But do you know the meaning of mafia? I don't know if you go to ChatGPT, ChatGPT is going to give you a definition, but mafia is mutual assistance for international arbitration. That's the right definition. So we are members of that organization. So I kind of made some notes here based on what I just read. And Marlon started by saying, oh, AI is changing the structure of legal department, legal work, legal, everything related to legal work. And my practice is in arbitration, in international arbitration, and in the last 10 years as arbitrator. So what I can see in my practice with my lenses are AI affecting, impacting counsel, outside counsel, in-house counsel, the parties, experts, legal and technical experts, arbitral institutions, and of course, arbitrators. So as arbitrator today here, I am a listener, I am a learner. In every single case, I learned something. And because of this multi-jurisdictional practice, so there are different arbitrators from different legal traditions, then you have different culture with, it's a subtlety, different ethical standards. And now we have the AI as a sort of intending to be a sort of a lingua franca. So AI, regardless if you are from Sweden, from Brazil, from Australia, from Nigeria, so you have ChatGPT, you have CoCounsel, you have everything, Pilot, and so how to use that? I can see as an arbitrator, the AI is helping me a lot with case management, reviewing documents, because as we know today, because of what you guys have just said, the petitions, the requests, the submissions have become so large, so humongous. So then you have to have some sort of a summary. What are the importance of everything that is putting before the tribunal? Handle requests to produce. Also, this reference schedule today has been tough because the amount of requests is also huge. Now, can I ask the AI to see or to help me, for example, saying what is important, what is material, what is overburdened here? So can I trust in what AI is assisting me, helping me, and then we're going to decide a very important, let's assume 100 requests. Then I say, no, this one is not a material. So I deny this one, but this one may be extremely important for this particular case. So going to your point, Felipe, I think we are still, fortunately, I should say, in a moment where AI can assist, but not replace. Especially in the decision-making process, it is very risky to rely on too much on AI. We are not going to deny the importance for being faster, quicker, and even more precise, but we have to have our touch and our feeling, our sentir, as Luciano said regarding sentença. Also, written statements. Written statements, AI can help us and is helping us to not only to check accuracy, to help us also to study before the hearing and asking questions, but also cross-reference to see if there is some cloudy statement in that written statement. So this is something that we don't have to rely exclusively what AI is saying, but it's a yellow light, so let me check. Let me go there and check. AAA/ICDR has partnered with ClearBrief, and this is something that is helping arbitrators and counsel as well. Someone mentioned here regarding the clause, I think it was Luciano, or no, I think it was Marlon. When you asked one question and then there was a clause, there was an answer. I believe the tool the AAA has, the clause builder. So when you are discussing the transactional word and what's going to be the arbitration clause, so you go to the seat, you go to the language, you go to the applicable law on the merits. AI, if it's an international case between a Brazilian and a Nigerian, between a Chilean and a French, and this is agency, for example. So can you please tell me how agency law in that other country is? Because I know agency in my country, maybe for this case, it's not the best, most appropriate law. So I think this is something that it creates nice and solid help.
Just one second.
No, go ahead.
I have a question. When does AI move from being when does AI move from being like your Westlaw database cases to something like a human that is, and when does the use, for example, of ClearBrief in terms of preparing an arbitration clause, for example, and if you get to the point in the common law where you have an ambiguity and you need to look to extrinsic evidence of subjective intent, can you then probe into the ClearBrief mechanism, what it did, And can you provide evidence of subjective intent with the cost?
It's a good question.
That's a good question. I do not have a precise answer
I
to
don't
that, but it's something that, again, this invites us to be more cautious. That's it. To me, that's the main problem is the full reliability. So this is so fast, and AI talks to you in a very friendly way. So you are kind of he or it engages you
Yes.
in a very nice, productive conversation. So and you end up liking he or her or it, whatever.
Yeah.
Uh, uh, you mentioned, of course, confidentiality, transparency. Now, I've heard that arbitral tribunals nowadays are disclosing to the parties that they are using AI. Is it a good thing? Is it a wonderful thing or not?
How does the arbitral tribunal have a license to conduct independent investigation into legal points, for example? Don't they have to depend on the parties? I don't know.
And also, it creates some sort of a perception in the eyes of the parties. So, what is it? What comes from this disclosure? Of course, insurance. You mentioned insurance. What if the arbitral tribunal or the arbitrator does something based on the AI? For example, the arbitral tribunal, with the assistance of AI, does not, well, creates an issue of due process. So I think that nowadays, professional responsibility insurance for, and I say for arbitrator, it is something that must be considered. As I mentioned before, I've been working as an arbitrator. Recently, I was invited to be a consultant in a case where this team has asked me to become part of the team as counsel. So currently my only case. And then we see the draft of the request for arbitration this weekend. And the lawyer told me, well, this was done with the help of AI. Okay, fine. But by reviewing the request for arbitration, I made a lot of comments and questions, etc. So to me, this is indicative that AI does not have the answer for everything. So we have to adapt, we have to adjust based on the facts that we know, based on the interview we had with the client. So of course, the request for arbitration is a very tiny, very easy, but that request for arbitration is going to follow you during the entire process. Luciano has mentioned the copy and paste issue. So that reminded me George Orwell with his Animal Farm. All petitions are equal, but some are more equal than others. So we have to still think about the George Orwell deliberation, arbitral tribunal. So are we going to how are we going to deliberate? So the three of us or the four of us?
What's mentioned also something I just kind of heard, I guess, from the news. I believe that in Albania, I think they have a minister that is an AI minister, I believe.
Yeah,
Right.
Benio.
And the real damage, I think, not the damage, but I think the real danger or warning light would be when decisions are being made. In other words, for example, you put in your arbitration clause that this algorithm is going to basically will take your arguments and everything, decide who wins and lose. I guess this is somewhat like a smart contract on the blockchain.
Let me pose a question, Maurice and everybody. Some people are writing saying, in a recent article, the arbitrator used AI, so the award must be notified. But many arbitrators use assistants, not artificial, but real ones. And I remember a paper in which the guy used as a parameter to analyze parametrics the name of the clerk. So they analyzed the clerks of the Supreme Court justices in the US where they graduated and created a sort of standard. The guy went to Yale, he or she went to Yale, there's a certain pattern because Yale Law School is this way, or then and if you take someone from Chicago School, then the clerk, why is that? Because it would be a proxy of the decision making. So why creating such an issue? I mean, what's the real difference between asking an assistant, human assistant, to write or to draft the procedural order and to report the case? And sometimes judges can say, well, because I used to work in the court of law, that judge would say, okay, listen, make the draft, sending this guy to jail. This guy go to the decision-making process was human, but all the labor of, because at the end of the day, the decision-making process should be of the one who is in charge of. Otherwise, written.
I wanted to say, I believe that there was an investment arbitration case where a party tried to set aside the award because the secretary of the tribunal wrote the draft report. And I think it may have been successful. And I think that might be one of the reasons I believe that the ICC stepped back with respect to what the secretary of the tribunal could do to a more purely administrative. Because there would be a belief, for example, if I pick you to be an arbitrator, I want you to do everything. I don't want anybody else to do anything. In other words,
Yeah, no, it's interesting, but I know some people who
me too.
have more than 50 cases.
Of course.
So, it's,
I think it's easy to think of the need to probably, we wouldn't call it regulated because it's not regulation, but I don't really think that most people have a problem with someone writing, like do the actual writing with an AI. It's the decision making.
Yeah.
So just using it, it's just like dictating a message to your phone or something like that. So I don't really think that most people, maybe I'm wrong, but I don't think the actual writing is what we care about. It's the decision-making process. You don't think so? Interesting. Even if you gave it like the key points for the letter and then you ask it to write.
Because if you don't like the decision, then there's some recourse against it. It's the writing that's going to be a large part of what determines whether you lose.
Yeah, I think of course, I speak in the world of arbitration. We can see today, once the award is rendered, we expect the parties to comply. Of course, there is room for filing motion for qualification. That's quite normal, quite reasonable. However, the motion for qualification today is an appeal.
Right.
It's a disguised appeal. So I don't know if outside counsel is billing a lot for filing this, and discussing with his or her client that how important it is to change what is somehow unchangeable unless there is, violation, due process, et cetera, et cetera. So I can expect that an unhappy party may see what AI has done that can be used in order to attack the war. So it is, we are seeing, so you mentioned, John has mentioned about the secretary. So maybe we are going to see more and more, depending on how courts are going to rule on this, how tiny or egregious was this award in terms of the use of AI. But let's be honest, everybody's using AI, or everybody,
Yeah.
everyone, even the courts have policies, how to better use AI. So everybody's using AI. So why, label as something bad for the case, especially for the decision maker? There is many other things that can be explored in order to check whether there is a violation of due process, etc. When Luciano, when you raised when you asked a question, I remember, especially in cases in Brazil, first or second question to the witness, at the witness stand, by any chance, did you have any communication with your lawyer? As if it was a sort of a silver bullet to kill the credibility of the witness. So, but the lawyer, yes, the lawyer helped the witness to draft the witness statement. And that witness is going to be subject to cross-examination. If he or she lied, it's going to be ready for cross-examination. So let's stop with just one final comment here, based on Paula, and I think language, translation, everything. I remember once I heard William Rusty Park. He mentioned the importance of punctuation and how to interpret same sentence with different punctuation. And the example he gave was a woman, comma, without her man, comma, is worthless. Now let's change the punctuation. A woman, semicolon, without her, comma, man is worthless. So we have the same sentence, the same statement with different punctuation, and we have completely different meaning. So can AI assist us to see or to check what the right interpretation is in that sentence, that statement? We'll see. So I thought that I should stop because.
Yeah, Luciano, take over.
A very famous arbitrator issued an exit opinion without a comment. Without 55 pages.
Well, I think it was Ian Paulson, huh? Yeah, I think I love it.
Yes, yeah.
Well, that's my final, actually, it's not a comment, but a question, perhaps a question to you or. And now going to not only arbitration, but litigation involving the use of AI itself, not the AI as a tool, but the AI as a subject matter of the litigation, or do you see something coming through on that law?
Start?
No.
So just to make sure I understood the question, so you are referring to AI as the arbitrator itself, for instance?
No,
So
no,
As a topic.
the AI,
Like the New York Times case with OpenAI.
Yeah. Yes.
Well, we already see some cases where people actually trying to do that, right? In terms of liability, I really see, I really don't see actually a legal justification behind the AI itself, nor the developers, at least for now.
with the current legal framework we have, if you understand how AI is being trained and now these models are being used or deployed, I really see it hard actually to see how liability would rise actually from this.
That's the thing. I think in Brazil, as always, we're gonna have massive litigation. Think about, we are now having cases in Brazil against pharmaceutical companies for COVID. And there was a specific clause saying no responsibility, no. And then the court said whatever, because it's a strict liability case, consumers. So if we consider the user a consumer, and think about, we have another view of law. Well, in our civil code, there's this strict liability for risk activities. Is it a risk activity like nuclear activities or not? Maybe you can raise this argument now. But then the view of AI considers some level of risks. Some activities are riskier than others. So if you are in this test of risky, then it's strict liability. So, I think companies might suffer some litigation. Not that I'm, in favor of it, but we're gonna have it for the outcome of the answers. Yeah, maybe.
Just one more quick comment up, and I'm thinking of it, if the idea of, let's say hallucination would generate liability for, let's say, AI, Microsoft, whatever.
No.
I think the whole business model of large language models will gone until hallucinations are solved.
Yeah.
And this would not happen in the next 5 years or so. So I think that the commercial interest, of the market will probably prevent or limit, I would say, the liability of hallucination-based, I would say, issues to probably a fixed liability or something that is more strict than just, endless, infinite liability. Otherwise, we cannot actually even use LLMs.
Right.
Yeah, I think you think of law as as a complex system, and you look at any complex system, they evolve, and they tend to evolve sort of in ways that are more predictable and unpredictable. And I think if you look at law in this instance, one of the things that I think the IP domain is very informative here when you go to understand the issues is sort of faced a very similar path when it came to search engines. And there were people suing all the search engines when search engines became popular in every jurisdiction. And Google bore the brunt of it, but Yahoo and Alta Vista and all of these other search engines were all like those were all getting sued for copyright infringement or misappropriating information from websites, even though at the end of the day, what really made that go away was people realized that commercial interests were in favor of the content being broadly distributed. But there's an equilibrium there as well, not to overuse that word, but for example, when Google ran its project, for example, extremely controversial intellectual property perspective, with them scanning and indexing all these books from libraries, making them available initially sort of in a limited way online because they were copyrighted. And Google and creators and found an equilibrium that was sort of mediated by the law. And I think we're likely to see something similar in this domain. I mean, we're already seeing litigation, New York Times litigation is very prominent, but there are, Dow Jones, all the major media companies, creator associations are in litigation. And there will probably be some sort of privately ordered type of arrangement that works for that in the kind of creative content space. But I think what's really important and like the kind of zooming out is this technology is more unique for search engines, and that the more access to information that these tools have, the better they are. And so there's this overriding social good there's social interest in favor of giving it access to as much information as possible for the benefit of society, if you think of it that way. Counterbalanced against the private interest of creating incentives for people to continue to create content and publish content and be creative. And so it's a really hard problem, but it's not the first time we faced it. We've faced the legal system faced this issue when it came to search engines. I mean, kind of like common study law around what all of that was happening. It was the hot issue of the day, and now we barely think about it. Like it goes, it's taken for granted. But of course, you can call the internet as long as there's some follow these industry norms around, maybe not indexing a page, people asking you not to. It's going to be the same thing. And I think content creators are going to get to the point where there'll be tags of content of no training or, no train, but you can't regurgitate this. People will figure it out at some point. And what that looks like now, I think it's very hard to predict, just like I think it was sort of hard to predict before search engines, in the early days of those disciplines. So that's where I work with a lot of technology companies. So they're all concerned about, data usage and our tools to be worthless if we don't invest data. It's not going to be one extreme or the other. There will be kind of a meeting in the middle. And I think a lot of us are probably going to be involved in helping the various stakeholders in that debate, trying to get to a place that kind of works for everybody.
So I guess, I have a different comment, and that was also brought by some of you regarding costs. It is not by accident that arbitral institutions are encouraging arbitrators and counsel to use AI, especially in situations where the fees or the arbitrator's fees are based on hourly rate. So you have institutions where the fees are based on ad valorem. So, and some institutions are hourly rates. So the arbitrator cannot these days say, I spent 5 hours reviewing documents or 5 hours preparing the timeline. So it doesn't make sense, to say the least. And even those institutions where the arbitrator's fees are based on the amount of controversy, etc. But then once the case is over or before deliberation for the final award, so comes requests for submissions on costs. So that also it is a message to counsel. So if they win, they can. So what is reasonable? That's the key question. So what is reasonable? So it is also something that it's not going to be, in my opinion, it's not going to be reasonable to have millions and millions of dollars. But if you break down and you check everything, you're going to see something that easily the AI could do.
I had a recent case at ICDR, which parties were Brazilian and US, and we had documents in both languages. And I came to an agreement with opposing counsel and the arbitrator that we would translate on AI the documents. And if there's a dispute, then we'll get a certified translation. Which is fun is that there was a couple of disputes, and then when you get the certified translation, I got my certified and they got theirs, and there were still disputes, right? Because clearly translated differently, right? But it made it exactly, and it made it cheaper. But I think especially in arbitration, there are a lot of tools that tribunals can use a little bit more. Translation of documents, maybe even because we had simultaneous translation, which is very expensive. And now there's AI tools that do that, so you don't need to have an actual translator there. And court reporter, exactly. That's what I was going to say. Well, I think we spent for 3 days of hearing, we spent like $16,000 in stenographer. And AI can do everything. Exactly. So even if you use like Fireflies or whatever, the Claude, they have a lot now that just transcribes everything, and you can have the whole reporting there. So I think for those issues, especially in arbitration, because ICDR, which is not ad valorem, our case was like, I don't know, a speed of $400,000, and we're spending almost half of that in costs. So it makes no sense economically. So I think for those issues specifically, we should use it even more.
So I guess we're running out of time.
Yeah.
So closing remarks. Again, we would like to thank the University of Miami, or Microsoft, our friend Marlon,
Thank you.
all you guys that joined us here. It was a very interesting discussion. Or and I are planning something bigger next year, maybe, right? More ambitious. Not that today wasn't big and wasn't ambitious, but just the starting point. And what Mauricio just mentioned is, or asked about, is something that I'm interested on. Which would be the best approach in terms of regulating AI in order not to avoid the investment in technology? Because Ador said, if we take the wrong path in Brazil, maybe it would be not good for business. And that's unfortunately ordinary stuff in Brazil, right? And maybe the opposite in the US. So yeah, Marlon?
No, that's it. Just, thank you everyone for coming and making all the way when Tim was talking about making the thing in the office. So you know what? We got more people with interest to go to Miami than to Fort Lauderdale, but we'll see who shows up. So, but I'm glad we had also the online broadcasting and recording. So that's it. Thank you very much for coming.
Can I make a picture?
Let me just shut off the.
Pretty nice initiative.
Yeah, it's Luciano. Luciano's doing everything.